Well, hello, my friends, and welcome back to another episode of Coroner Talk. I am so happy that you have joined me yet again. We got a great episode today. I know I always say that, but they're always great episodes. Today, we're going to talk about courtroom testimony, and you think, oh my God, what a boring topic. Yeah, I get it. It can be a little bit boring. However, it can also be a little scary, especially if you've not done it. And for those of us that have done it a lot, we can still get a little nerved up every once in a while. And there are some ways to testify correctly, and there are some ways to testify incorrectly. So today we're going to talk about how to prepare and how to do it right and how to do it wrong. So if you've been to court 1,000 times, then this episode might be some good reminders for you. If you've never been to court, then this is going to be some good preemptive training before you have to actually get there. And if you're listening to this episode when it comes out live, it is the day before Thanksgiving, 2022. And I just want to say that I'm thankful for you. I'm thankful for this podcast. I'm thankful for the ability to be able to meet with you and talk with you. And I always love it when I'm at a conference somewhere, as I was in Iowa just a few weeks ago, actually, and someone came up behind me. I was talking to somebody, and kind of when that conversation broke off, someone had said, "Hey, are you Darren Dake? Are you the podcast, Corner Talk podcast guy?" I said, "Yeah, I am." And they said, "We recognized your voice because they heard me, from across the room or wherever they were at. And so they recognized the voice. And so then they put two and two together." So I always love that. I always love people who listen to podcasts come up and say something, and I get to introduce myself and get to know you. So if you're ever at a conference and see me, please come up and do that. I love that interaction. Now, I've been trying not to take a lot of time on the front end of these episodes to talk a lot about training and things like that, and just get to the topic. And I still want to continue to do this, but I have an announcement I really want to make sure I make. Number one, don't fast forward. Give me just a second. Number one, if you haven't subscribed to the newsletter, the magazine newsletter, please do that. You know, it's a great monthly magazine that comes to you free every month. Lots of information. And the other thing I want to talk to you about is the week-long medical legal death investigator class that we have here in Missouri. That has been modified and changed. So starting in 2023, instead of it being in my local area, we have moved it because we've outgrown all of our area around here. We have found the most economical place to have this course is going to be in Springfield, Missouri. Now, it's going to be in April. Instead of March and October, next year it's going to be April and October. And we have expanded the course. It's still 5 days, but you have 5 days of classroom training. Then you're going to have another 20 hours worth of online training given to you after the 5-day training. Plus, there's an airport in Springfield. There's a free shuttle between the airport and the hotel. It's going to be at the Oasis Hotel and Convention Center. Plus, breakfast and lunch is served every day as part of the cost. There's a hospitality room. So think about a conference you've ever went to before, and this is going to kind of be conference-like. Now, it's going to be training, and we're going to be in the classroom every day. We're going to be interacting with instructors, and it's going to be, a full 5 days worth of training. But there's some perks associated with that will, that makes this even a better training than it ever was before. The cost is not really any more than it was before, considering everything else that's involved. And you also, there is a hotel rate, but the hotel is a government rate. And so the cost probably is going to be less for many of you than it was before because of the cost of travel and meals. So that's something to look at. So you can go to our website and go to the Academy page, and you can see the Medical Legal Death Investigator course. There's one in April. There's one in October. You can sign up for either one of those or both. We have expanded the amount of people can be in there. We're now 50, around 50, a little more than 50. And we've already got 30. So we're going to fill this class. So if you are interested in being involved in that April class, please go check it out and get registered. And we would love to see you there. It's going to be a new venue. It's going to be fantastic. It's going to be a lot of fun. We're all going to stay in the same hotel. That way we have the time at night at the hospitality room, things like that, to get to know each other. It's just going to be a great time. And besides, you're in Springfield, and you think, well, what's in Springfield, Missouri? Well, number one, it's the world headquarters to Bass Pro Shop. You may not care about that, but we're right next to Branson. And so if you want to run down to Branson one evening or if you're going to stay an extra day over, something like that, there's a lot to see. So I think it's going to be very beneficial. But check out that training. Of course, we have a lot of online training, things like that. And I'm traveling all over the country in the next several months, and I may be coming to your state. And if you want me or one of our instructors to come to your agency, just let us know. We'll try to find a topic that fits you, and then we'll come to your agency to host that training, which, usually 2 and 3 day classes is what we can bring. So anyway, check that out. And so I know that you'll love coming to the April MDI class next year. All right, with all that out and said, let's get into today's topic, which is courtroom testimony and preparation for court. It's not going to be boring. You're going to learn a lot. And then on the back end, I'll be back and I'll give you some final thoughts.
Adjust your earbuds, turn up those speakers, and hang on. It's now time for this week's featured conversation.
So one of the first things to understand is there are 2 types of witnesses in any court action. There's a factual witness and there's an expert witness. Now, a fact witness is someone that has personal knowledge of the events pertaining to a case and can only testify to the things that he or she personally has observed, seen, or done. Now, an expert witness is someone that offers an opinion, and that may assist the judge or the jury in understanding maybe a specialized technique, maybe something to do with the science or forensics, but otherwise would be beyond the normal person's expertise. They are an expert witness. So I have to ask, could someone be a fact witness and an expert witness at the same time? The answer is yes. You may be asked about what you did and what the defendant did. You'd be a fact witness. And then you could also be asked to state your opinion, and then there you'd be an expert witness. So this comes up sometimes when you're dealing with an inquest. Of course, during an inquest, the rules of court are a little bit different. But also in a criminal case, you can be the fact witness and the expert witness, depending on the kind of the case itself, and obviously in civil cases as well. Example would be that you saw a suspect walk into a store with a gun, and you thought he was going to commit a crime. Well, the fact is you saw somebody walk in the store with a gun. The expert witness portion is you thought he was going to commit a crime based upon your knowledge, your years of experience, and of course, the common sense would tell you that very likely could happen. Now let's talk about preparing for your testimony. You need to have a well-organized, standardized, complete, and readable report. A lot of times I see people going to court and they've got this pile of stuff that is just in no way in any type of order. And so it's very hard to prepare for testifying when you don't have things in a good order. Supplement standard forms and checklists with your own words to help explain potentially confusing situations. There's a lot of checklists out there. There are a lot of scene checklists and report checklists. Those are fine. But if they get confusing to you, then replace that with something you can understand. Your own words, your own way of saying things, and that way it'll help you when you do get ready to prepare to be able to testify based upon your knowledge and your own understanding. And then, of course, it's okay to draw pictures to help describe things and to jog your memories during court. These are papers that you're going to be able to look at. Now, they can be put in as records, so be careful what you do right in there. But obviously, pictures and diagrams are a good part of your summary. Now, you should review the case several times before you go to trial. So you've been called, you got a subpoena, you know when your court case is. You should review the case several times before you get there. You should also meet with the prosecutor and review your testimony. What is the prosecuting attorney going to ask you? What does he or she feel is the most likely defense that you're going to have to overcome? And how best do they want you to prepare? And you need to mentally rehearse the case, going over the facts out loud. Talk about the facts. If he asks you questions, prepare your answers. You can do this alone, in your car, in your house, whatever. Just do it somewhere where you can actually prepare and get used to answering these questions out loud. It'll help you when you get to the actual witness stand not to be so fearful. And if need be, visit a courtroom and observe other trials in progress. If you've never testified in court and this is your first time, then yes, go somewhere where they're having court and watch as court proceeds so that it's not something new for you and some of the anxiety of newness is over with. Now, ask yourself long before you ever get to court, is your report complete and accurate? A report should be written in chronological order of your investigation or your involvement from the time you received the call, got the information, seen the situation, was contacted by someone else. That's where it should start. And it should be in chronological order until you have completely finished your portion of the investigation. That way, anybody coming along later can understand it, and you can understand it as well. Easy to understand reports need to not have short codes or police jargon. We don't, sometimes car accidents, if there is a deceased in a car accident, we'll refer to that as a 1050 J4. 1050 being the accident, J4 being someone is dead. You don't want to put that in your report. You want to just simply put what it was. Traffic accident, someone was dead, someone died, however the situation is. Don't use short codes. Don't use things that are for your department, your agency, because someone else might pick that up and not be able to understand it. And be sure that any words or phrases that you use in your report, you can explain later. The biggest embarrassment you're going to have is when you have to look up one of these $5 words when you're explaining an injury or an illness, and then when you get to court, you don't remember what that word meant. Or you can't explain it correctly. Because I promise you, the defense attorney is going to have 5 more words for you to explain and make you look like a real idiot. Now, if you know what the word means and you can explain it, then by all means, use it. If you're going to use the word myocardial infarction, make sure you can explain myocardial infarction. If you're going to use the word laceration, make sure you know the difference between a laceration and an incised wound, because the defense attorney is certainly going to look that up, and he's going to be asking you. And if you can't describe the difference, he's going to make you look like an idiot. So you can use things like defects, or you can marks on the body, appears to be, but be sure whatever phrases you use, you can explain. Now, your opinion can never be reflected in your final report. Someone may ask you your opinion, the prosecutor or even the defense attorney, but in your final summary report, it can only be the facts as you have done them and know them. Now, in your investigative notes, certainly you can have some opinions in there, but your final summary must have facts only. Now, when you get to court, make sure you have a complete report with you, and make sure you have reviewed all of these reports, meaning the autopsy report, the toxicology report, and anything else that may be related to that. Make sure you look at the evidence logs. You know what evidence has been put in. Do you have the evidence? Did the prosecutor ask you to bring the evidence with you? If so, you have to go sign for it and bring it to court. Keep it with you until you return it to the evidence. But make sure you have reviewed all of that long before you get to court, and then again, either the day of or the day before. Now, let's talk a little bit about pretrial stress. The 1977 bestseller Book of Lists? Now, in it talked about the 14 worst human fears. And the number 1 is speaking in front of people. And number 2 is dying, by the way, which means we would rather die than get in front of people to talk. When it comes to court, not only is there the fear of talking in front of people, we also have the fear of the weight of the court, actually. We're there, it's court. You don't want to be wrong, you don't want to lie, you don't want to look like an idiot. So all of these are fears, and so there's a lot of stress built up on it, even more so than just if you were speaking to your peers about something. But you can overcome this fear. So I want to talk a little bit about how to overcome some of this fear and some of this stress before we actually get into some real courtroom testimony. Now, this fear can be overcome by mastering 2 skills, breathing and relaxation. Breathing and relaxation. If you can master these 2 skills, you can overcome your fear in court. So breathing. It's something we all do, obviously, and we don't even think about it. And so for so many people, military and posture training has resulted in poor breathing habits. Military trains us to breathe one way. You breathe when you shoot. Certain postures, the way you sit helps you breathe. But a problem is that is poor breathing habits, So ask yourself, do you think you're breathing correctly? Probably not. Let's look at that. The diaphragm is a muscle located just under the lungs. Now, most of us know that. And when the diaphragm flattens, it creates a greater space in which the lungs can be filled. And when the diaphragm returns, the air is literally pushed out of the lungs. So to see if you're breathing properly, stand up, close your eyes, hold your fingers on one hand just under your rib cage, 2 or 3 inches above your belly button. Inhale. Now you should feel here that the muscles will move up and down, and you can feel that through your fingers. Now relaxation. Fear, tension, and or stress can cause your muscles to tighten. And this can be fixed by completing a simple exercise. And just before you go into court, do this exercise. Just excuse yourself to the bathroom. I don't mean when they call you to testify. I mean just make sure before you go to court, before you go into the room, excuse yourself to the bathroom and do this exercise. Stand up, tense your toes, and just actually drill your toes into the floor. Make them tense. Tighten your calf muscles. Move the tension up to the thighs and into the hips. Tense your forearms. Moving the tightness up into your arms and in your chest and down into your stomach. Tighten every muscle in your body. Go into your head, your neck. Your body should be so tight from tension that it's shaking. Now raise your arms over your head and stretch as far as you can. Now, totally relax. Drop your arms, loosen all those muscles, and you can feel a surge of well-being taking over. It is a fantastic way to relax. If you're in a stressful situation, you can do this as well, not just court, anytime, and it will help you to relax. Now you're relaxed, your fear is gone, and you're ready to take the stand. Now let's talk about what happens when you actually take the stand. You're now relaxed, you're feeling good, you're prepared, you reviewed all your reports. Now you're ready to actually take the stand. Let's see what that looks like and what you have to be prepared for there. So on the stand, you need to really watch your demeanor. You should have a general attitude of confidence, but not cockiness. You should be confident. You know your report. You know the case. You were there. It has no problem with you being confident. Just don't act cocky because that will ruin you in court. And you should remain composed. Investigators convey an air of authority and respect. Death investigators, coroners, medical examiners, police officers, investigators of any kind convey an air of authority. The way you're dressed, the way you walk, you sit in the chair, and everybody knows that you're authority even without saying so. So, your demeanor should reflect that. Body language. Sit straight up in your chair. You need to sit close enough to the microphone so that you don't need to lean forward every time you have to speak. Your material should be well organized and in front of you. You should look at the attorney questioning you, then look at the jury when you answer. Now, if there is no jury, then just continue looking at the attorney. But if you're in a jury trial, the attorney asks you a question, look him in the eye, hear the question. When you get ready to answer, turn and answer the jury. You should be open, friendly, and speak clearly and slowly. Your body language is going to tell a lot about you. And when you talk clearly and you talk slowly, then that makes you even more confident, and that makes you appear to be more confident and ultimately helps you to relax. Because you're not talking so fast that you're getting ahead of your thoughts, and you're actually able to think about your answer and answer it in a slow, confident manner. Now, when it comes to answering questions, listen carefully to each question and to give a responsive answer. If you don't know or understand, ask the attorney to repeat the question. Sometimes attorneys just ask questions because they know what they want to know, so they ask a question that doesn't make a lot of sense. Sometimes an attorney is actually trying to trick you, especially if it's a defense attorney in this case. So make sure that you understand the question before you answer it. And if you need to ask for it to be repeated or reworded or reclarified, you have no problem asking that. Keep your sentences short and to the point. If you don't know the answer to a question, simply state, I don't know. Never try to guess. If you need to refer to your report, then you might have to say, I don't remember, but if I could refer to my report, I could get you the answer. Because attorneys want you to answer without reading your report every time. But if you need to refer to it, they generally will allow you to. If not, then simply say, I do not know or I do not remember. Never guess, never assume. Your testimony has to be based upon facts. And if you don't know that you know the facts you're getting ready to speak, then don't answer it. Just say you don't know. Now, the don'ts on a stand. You should not try to bluff your way through a difficult question. As I just said a second ago, if you don't know the answer, you don't know the answer. Answer the best you can and leave it alone. You should not become defensive or dishonest. Now, let's talk about each of those. Defense attorneys sometimes have a way of making you become defensive. I know in my case, I can get defensive sometimes when an attorney is trying to make me look stupid. When I know what I'm talking about, but they're trying to change my words or do something to make me look incompetent, I get defensive. The problem with that is it can actually add to their case of me looking incompetent when I become defensive. So I've got to really watch myself not to. And above all, don't become dishonest. Again, don't lie. If you don't know, you don't know. Also, it is not your job to convict anybody. Your job, let's say as a police officer or the investigator, is to report the facts as you know them. Now, if that convicts a defendant, fine. If it does not convict a defendant, fine. Your job at court is to testify to what you know to be true. How it comes out is not your problem. So when we try to help the prosecution by adding to our answers, what we're doing is being dishonest and many times are going to backfire and will ruin the case rather than help the case. And do not start your answers or preface your answers with phrases like, I believe, I estimate, or to the best of my knowledge. This can leave doubt in the minds of the jury or the judge. Just say what it is. And again, if you have to refer to your notes, then do so. There are times that you might say to the best of your knowledge, depending on what the answer is or the question. But be sure those are limited, because if you start believing or estimating or the best of my knowledge, basically, are you guessing? Do you really know the answer? And if you don't know it, remember, I don't know or I don't remember. Those are the best answers. And you should not answer beyond the question. If it's a yes or no question, then just answer yes or no. If they ask you, what is the first thing you did when you arrived at the scene? Your answer could be something like, when I arrived, I exited my vehicle and I asked for the investigator in charge. And I was pointed to Detective Jones standing near the corner of the house. That's your answer. And they may ask, okay, then did you contact Detective Jones? What did you do next? And then that's fine. If they ask what you did next, you say, I made contact with Detective Jones and I introduced myself, showed him my credentials, and let him know that I was the medical legal death investigator there for this case. I asked him if he could show me where the body was located and brief me on what they know so far. That's it. That's your answer. You don't need to start telling your whole report. You don't need to spend 20 minutes answering a question. What did you do next? What did you do next? Answer that question and then be done. But they're not wanting a 4-hour narrative. Now, let's look at some proper testimony between an officer and an attorney. So the attorney says, Officer Jackson, you say you saw the defendant take 2 drug vials out of his pocket. How far away from the defendant were you when you made this observation? Officer, about a half a block away. The attorney asks, how many feet would that be? The officer says, I don't know. The attorney says, "Surely, officer, you can estimate the distance. Was it 100 feet, 200 feet, 50, 10? The officer, "I really can't accurately estimate the number of feet, but on that block, between myself and the defendant, there was a liquor store, a dry cleaner's, and front steps of a post office. The defendant was standing right next to the first step, close enough to observe his hand movements very clearly." Well, that's a good testimony. That's good question and answer. No, don't be estimating. The attorney wants to trick you. Don't be saying, "Well, I think it's about 150 feet or whatever." You don't know how many feet it was unless you've measured it off. So you just have to answer it accurately. Now, criminal versus civil. Now, all the information we just talked about applies to both criminal and civil cases. It doesn't matter what the case is. It's up to you to just be truthful and honest in all that you do. The main difference, though, is the stakes for law enforcement personnel in a criminal case are higher, with a lot of time and effort into prosecuting an individual. And, of course, for us, for law enforcement, we want that case to be a successful prosecution. So, in conclusion, most citizens, including juries, want to believe that the people that they've placed in charge, they have their trust, such as public safety employees, you as a police officer and investigator. They have your best interest in mind. But if a witness crosses a jury through dishonesty or disrespect, jurors will react negatively. My point here is this. Don't make juries mad because of your demeanor, because of your attitude, because of your flippant attitude towards a defense attorney, or your lack of preparation and your lack of knowledge of the case. Prepare for the case, answer the questions completely, and you'll do fine in court. And you'll gain the trust of the juries when you act with good demeanor, you act confidently but not cocky, and you answer the questions clearly directed to them. And in most cases, that's all you need to do, and you'll have a very successful outcome. All right, I'm back with you. So I know you got something out of that. Great podcast, great information out there. So if you have thoughts, send me an email. If you have something you'd like to add to that, send me an email. Of course, you can tell that it was part of an online class. It's not all of it, but it was part of an online class. So if you want to get the rest of that, you can, of course, go to the Academy site and find the courtroom testimony course and jump in on that. And for the next few episodes, I'll probably use excerpts from some of our online classes. I know we've been doing that a lot for the last couple of months, but people seem to like it. Some of the comments that I get from you guys is that you like it. It's training. You're getting actual good training, and it's not necessarily me just rambling along about whatever happens to be on my mind at the time. Of course, I do a little of that because, I got a mic in front of me and I can talk. But I do try to give, fantastic, great training to you every single episode. So again, this is the season of Thanksgiving, the season of Christmas, and more than any other time, this is the season to be a blessing to someone. So find a way to be a blessing. We live in a very screwed up world, and blessing someone in your life is just going to pay you back tenfold. Don't do it for a payment back. Just understand that you're making the world a better place. And if you can make your little bubble a better place, then all the bubbles become a better place. So have a great Thanksgiving. Have a great Christmas season. And until next time, be safe.
Thanks for listening to Coroner Talk, a DSPN media production. Visit our website at coronertalk.com. And be sure to like us on Facebook at facebook.com/coroner training. 3617 1024 scene en route to morgue.